Okay. All right. Welcome, everyone. I'm Diane Monig. I'm the Director of Programs here at the Arc of Northern Virginia, and we are thrilled to have Nicholas Thompson here presenting for us today. Um, Nicholas is an estate planning and special needs attorney with Pender and Coward. Nick currently serves and is an adjunct professor leading the University of Richmond School of Law's Aging and Disability Practicum. And he previously served as an adjunct professor and the director of the William and Mary Law School's Elder and Disability Law Clinic from September 2020 through 2024. So, Nicholas, we're thrilled to have you here today. Just as a reminder to everyone, this session is recorded. I will be sending out the recording along with the slides to everyone. So with that, Nicholas, go ahead and take it away.
Awesome. Thank you, Diane. Yes, so as Diane indicated, I'm a Virginia-based attorney. My practice focuses on guardianship, estate planning, and special needs planning. In addition to formally directing William and Mary's Elder and Disability Law Clinic, I currently serve on the Hampton Newport News Access to Justice Committee, and I am the guardianship triage champion for the Central Virginia Legal Aid Society. So when attorneys take on these matters in a pro bono capacity, they can reach out to me and ask questions. And then my contact information is on the bottom bullet there. Should you have any questions afterwards, please feel free to reach out. Next slide, please.
I do want to mention, I neglected to say in the beginning, if you do have questions, please put them into the Q&A box and we will get to those.
Perfect. So at the outset, we'll start talking about estate planning and decision-making alternatives. This will cover wills, special needs trusts, advanced medical directives, powers of attorney, and then we'll end with guardianship and conservatorship. Next slide, please. So, why would somebody have a will? What does a will do for you? Well, it lets an individual, known as a testator, name their beneficiaries. That would be who they want to receive their property when they die. This includes naming a special needs trust as a beneficiary in lieu of a disabled child. And this is critically important for family members of individuals with disabilities because, as many of us know, and if you don't, this magic $2,000 number will be ingrained into your head. The individual should not have in their possession more than $2,000 or could really jeopardize the public benefits that they receive. This help lets an individual, a testator, name an executor, a person who is responsible for administering their estate. It allows an individual to give specific articles of a property to specific people, right? For example, mom might want her earrings to go to her oldest daughter, or dad might want his shotgun to go to oldest son. So it allows people to make specific gifts to specific people. And this one always makes me chuckle. In theory, it prevents family disputes after death because the individual has clearly laid out their wishes. And to the extent the individual has minor children, it allows that person to nominate who should be the guardian of those minor children when the individual passes away. Next slide, please. Among other reasons for having a will. If somebody doesn't have a will, that's what we call intestacy. And intestacy is a default set of rules in which our state or our commonwealth attempts to approximate what a typical decedent, person who passed away, would do with their estate, right? Typically, this is going to favor the family of the decedent, and this includes special needs children, right? So sometimes people say, well, the law will just take care of, what I would do anyway. And while that may be true for parents, especially of children with special needs, this can create problems, right? If property passes via intestacy, right, maybe they have three children, it will go theoretically evenly to each of their three children. And as I mentioned on the slide before, if that individual with special needs has more than $2,000 in assets in their name, that can create benefits problems. Next slide, please. So, what is another tool in our toolkit for estate planning? Well, special needs trust, sometimes called supplemental needs trusts. And these are legal arrangements that are created to ensure that assets can be used to support an individual under a disability without disqualifying them from public benefits. So with special needs trust, there's no $2,000 limit to resources that can be in there for the benefit of the individual. There's not a cap on how much can be in a special needs trust. And so these funds and resources can be there for the individual to supplement their needs so that they can retain their public benefits. Generally, people ask, can I just pull one offline? Maybe self-seeking advice, but I would say no. It's very important that you contact an attorney is, uh, who is in the special needs world, knows special needs trust, because the trusts themselves must comply with both federal and state laws. So hiring an attorney is very and critically important. Next slide, please. Just a few definitions as we talk about them. A grantor, so this is the person who's creating the trust and generally contributing assets to it. Sometimes this person is also referred to as a settlor. Trustee, who can be the same person as the grantor, but the trustee is the person or entity responsible for managing the trust, making investment decisions, and making distributions to beneficiaries in accordance with the special needs trust terms. Beneficiary, I've used this word a few times. This is the person in the special needs trust context. This is the person with a disability or special needs for whom the trust is established to provide benefits. Remainder beneficiary, these are individuals, not the individual with special needs, who are to receive any remaining assets in the trust once the beneficiary passes away. On the next slide, we'll talk about first and third party special needs trust and some of the main differences. But another sort of trust that I'd like to mention is a pooled trust. And these are trusts that are under the management of nonprofit organizations. If you have questions about those, I would certainly suggest you reach out to the ARC of Northern Virginia as they run a great one. Next slide, please. So some considerations when we're thinking about setting up a special needs trust, we want to think about what's the life expectancy of the individual, right? Do they have a normal life expectancy and we think they're going to live for another 40 to 50 years? That might adjust how we fund the special needs trust and how much we fund the special needs trust. This leads to question two. How much money are they going to need to maintain their desired quality of life, right? When and how should funds be distributed? Should the trustee have control over trust funds, or should we have some third party who helps to oversee spending and ensure that the funds are there over the course of the individual's life? And then ultimately, again, among other considerations, what should happen if there are funds remaining in the trust? Should they go to other family members? Should they go to a particular charity? So that those are things that we consider when we're setting these up. Next slide, please. All right, I mentioned a couple slides ago, we're going to talk about two different kinds of special needs trusts, and it's important to try to understand the distinction here. So a first-party special needs trust utilizes assets that belong to the beneficiary, to the individual with the special needs, right? Sometimes somebody might receive, let's say, an unexpected inheritance, right? I mentioned 4 or 5 slides ago that it's important for parents, especially of special needs children, to do their estate planning. Maybe mom and dad didn't, and mom and dad passed away, and now special needs child has received an inheritance. Well, they're likely going to need to have somebody set up a first party special needs trust with them because they now have assets that are going to disqualify them from their public benefits unless they're in this first party special needs trust. Sometimes folks call this a self-settled trust. And these are irrevocable, and as I mentioned, are generally funded with some sort of inheritance. Maybe there's a life insurance payout or personal injury settlement. With these first-party special needs trusts, unlike third-party special needs trusts, there is a Medicaid payback requirement. So if the individual passes away and there's $50,000 left in the first party special needs trust, and Medicaid over the course of that individual's life paid out $1 million in benefits, they will come and request to be paid back for the $50,000 remaining in the trust. Now, third party special needs trusts, in contrast, are established and funded by someone other than the individual with special needs, other than the beneficiary. Generally, these are established by family members. They can be irrevocable or revocable. And while they can be funded during life, they are generally funded at death via life insurance or some other bequest. Um, this is a reminder to me, and I don't have a slide on this, I need to add one, but it's critically important to focus on how assets are titled as well, right? And this came up recently. Parents did everything correctly. They set up the special needs trust, they had the life insurance, everything was ready to go, except they did not update the beneficiary on the life insurance policy from the individual with the special needs to the special needs trust. And that created an expensive, time consuming problem. So, while we're doing our estate planning, we're also going to be talking about titling. And then the last bullet here, unlike the first party special needs trust, the third party special needs trust does not have any sort of Medicaid payback requirement. Next slide, please. All right, so what can special needs trust funds be used to pay for? What sorts of benefits can they cover? Well, they can cover educational expenses. The next slide or next bullet is a very popular one. They can cover entertainment and travel expenses, such as a trip to Disney, home modifications, accessibility. Um, as long as the medical or dental expenses aren't covered by insurance, they can cover those, again, supplemental needs, professional care services, rehabilitation, and even transportation and vehicle expenses. Next slide, please. And while she's getting to that next slide, a complement to special needs trust are ABLE accounts. I don't have a slide on that, but there was a great talk on those last month with the ARC of Northern Virginia. So if you're not plugged into their newsletter, their monthly newsletter, get on that. They have great resources and a great data bank of former events and speeches. So take a look at that. But ABLE accounts are another great resource to have benefits for or have resources available for the individual without disqualifying him or her from their public benefits. All right, so we've got the special needs trust. Another tool in our toolkit here is an advanced medical directive. This is a written set of directions that an individual, sometimes called the principal, gives to an agent to give them direction and guidance as to that individual's future medical care in the event of their own incapacity. For example, I might have an advanced medical directive that says, if I'm unable to make my decisions, I name my wife to make my decisions. Right? I don't have any adult children, but if I did, it might say I name my wife, and then if my wife's unavailable, I name my enter name of adult child, or enter name of parent or sibling or whomever. All right, these documents can provide for very specific kinds of treatments and requests. For example, it might say, under no circumstances am I to go live in a nursing home, or under no circumstances may I have a blood transfusion. So we can provide for very specific kinds of treatments and requests in these documents, giving an agent direction and guidance as to medical decisions. Next slide, please. The complement to the advanced medical directives, I think that's for healthcare and personal decisions. The complement to that is a durable power of attorney. So this is, think, financial, estate decisions. So similar document, except in this instance, it's a written set of directions given to that agent to give them direction and guidance to an individual's future financial care. Okay, so in the event that I'm unable to make appropriate financial decisions for myself, again, I might name my wife to make decisions for me. And while these two can provide for very specific kinds of actions, they often give the agent a more generalized authority to ensure that they can fully and appropriately manage the individual's finances for their benefit. One must have the capacity to enter into an advanced medical directive and a power of attorney. And this capacity level is generally the ability to understand the nature and consequence of the action, right? What does this document say? What does it do? Do I want to give this person or these people this authority? Next slide, please. Now, if I don't have that capacity, right, maybe I don't do my estate planning and I'm 85 years old and I develop dementia or Alzheimer's, someone is likely going to have to go through the guardianship and or conservatorship process for me. All right, and so we'll walk through what those code requirements look like, what that timeline looks like, and then finally some misconceptions. Um, and as Diane indicated, I know there are tons of questions about this topic. If questions pop up, please do just put them in the Q&A, and Diane, feel free to interrupt me. Have we had any questions so far?
No, not so far, Nick.
All right, very good. If you want to save them to the end, that's fine too. All right, so just a quick couple important definitions, and I'll go in bottom to top order here. So a guardian, this is a person who's been appointed by a circuit court who has certain powers and duties. They're set out in these code sections, and they're responsible for managing the personal affairs of an incapacitated person. Think decisions about their health, their care, their safety, the support, their habitation, their education, and therapeutic treatments. Okay. And then we have a conservator. So the guardian corollary is like that agent under an advanced medical directive. And remember, our other estate planning document was a power of attorney. And the corollary for that is a conservator. This is a person who's appointed by a circuit court who's responsible for managing the estate and financial affairs of an incapacitated person. Okay, and then we have an annual report. I always want to include this one because it's due annually, every single year for guardians. And these are reports that ask for information about the individual, and they get submitted to the Department of Social Services where that individual resides. It's critically important so that we can ensure that there's an appropriate decision maker for an individual needing one at all times. Next slide. All right, so yeah, you can go back one more. I did you skip two? They both look kind of similar. Um, yeah. All right. So these look kind of similar, and I intentionally am breaking the rules of slides by including too much information. And the point here is to drive home the point that the court has to consider and is supposed to be provided a ton of information. That's because it's important for them to know that this person does, in fact, need a guardian and that the individual or individuals asking to be appointed are appropriate people. I'll point to just a couple of them. The third bullet down says the names and post office addresses of the respondent's spouse, adult children, parents, and adult siblings. Okay, this means that, to the extent the person has both parents living, both parents' names and addresses should be provided. Again, that's to the extent known. If the individual has adult children or adult siblings, those people should be listed. And if none of those are known, then we need to include the names of 3 known relatives and their addresses. And we'll talk about this in a few slides. That's because eventually we'll send out a notice once we get everything filed and a hearing set. All right. If you'll also point to bullet number 5, second from the bottom. So we're supposed to include the name and residence and address of any agent under a power of attorney or advance directive. Right? If the individual has entered into these documents, the court wants to know about that because theoretically they're going to tell the court about who the individual wants to help them make decisions. Next slide, please. Again, more information. All of this has to be included in the petition. So when you get an intake form, it's helpful if you fill it out thoroughly because the attorney is going to have to provide all this stuff. Okay, and I'll point to just 2 on this slide. So the second bullet, so when we're requesting a guardian, we need to provide a description of the services they're receiving, right? So are they getting speech, occupational therapy, physical therapy? Do they have an IEP? Are they living in a nursing home? Those sorts of things need to be provided to the court because we're supposed to make a recommendation as to their living arrangements. Okay, and the last one that I want to note is that a request for the appointment of a guardian ad litem. So that's going to be included in all of our petitions, and this individual is going to play a critical role. This attorney, I should say, is going to play a critical role in the process, which we'll talk about in the next slide. in 2 slides. We also submit a confidential medical evaluation report. So this is a report that's going to be filled out by a licensed physician or psychologist or some other licensed professional that's skilled in the assessment of the condition as alleged in the petition. Okay, this report gets filed under seal with the court, and it's only provided to the guardian ad litem, to the respondent, the individual under disability, and all of the individuals who are entitled to notice in the proceeding. Remember, I mentioned that bullet about parents, adult siblings, spouse, and adult children. Next slide, please. All right, so we've gotten everything filed. The court's given us a case number, assigned us a guardian ad litem. Now what? Okay, so once it's filed, the code says the court shall promptly set a date, but really it's the attorney that reaches out to the court to set that hearing date and time. Okay, the respondent, again, the individual who's under disability, has to be given notice of the hearing. So this notice is going to get personally given to them, right? And they can't waive notice. So you can't say, oh, they were unavailable or they had moved to Fairfax and this isn't Chesapeake. They have to receive notice in order for the court to have jurisdiction, meaning in order for the court to have the power to give somebody authority under a guardianship. Okay, so we set that date and then we mail out a notice. And the notice might say, on April 15, 2026 at 9 a.m., Jane Doe is going to ask the circuit court for the city of Chesapeake to appoint herself guardian and conservator for John Doe. Okay, and that gets mailed out to all of those people that we listed in the petition, right? So all those relatives. And I forgot to mention this bullet. It also goes to the person's primary healthcare provider, okay? And then it gets given, hand delivered to the individual. Okay, the notice has these big, bold 14-point type warnings that tell the person that they're entitled to, they have a number of rights. They're entitled to the right to their own attorney if they want one. They're entitled to put on their own witnesses. They're entitled to cross-examine witnesses, including the medical evaluator. They're entitled to a jury trial if they so request. So they have lots of rights in this process, albeit they typically aren't invoked because oftentimes it'll be, parents becoming guardians of their soon to be adult child or recently turned adult child, and everybody's on the same page. Next slide, please.
Nick, I just want to stop you there for one
Yep.
second. Um, I had a problem with the Q&A box, but now
Oh,
it is open for questions.
okay.
And I see that there are two questions in there. Do you want to stop for a minute and
Yep,
take
go for
these?
it.
Okay.
Go for it.
Can special needs trusts be set up to provide for the beneficiary's home, apartment, food, monthly expenses, or is that a different type of trust?
Yeah, so generally they're supposed to cover things above and beyond what the public benefits cover, right? So to the extent that the individual's social security and or waiver cover those sorts of resources, they're not supposed to pay for those. Now, the special needs trust can certainly own a home, right? Sometimes parents will leave their home if, maybe their child lives with them and they want to leave the home into a special needs trust along with other funds, right? Because as hopefully we know, there are lots of other costs and expenses associated with home ownership. And so it's important that you don't just put a home in a trust because then they're like, well, there's no funds to pay for the taxes and upkeep and that not. But typically, it should only cover what the public benefits don't cover.
Thank you. Here's another one. Can there be a special needs trust with two beneficiaries?
Typically, I would separate them out, right? And if you're having the same attorney draft them, and they're going to be very similar provisions, meaning like same trustees, same date you're setting them up. If they're for siblings who live at the same address, it shouldn't be that much more, frankly, time or expense to do too. If a lot of the bones are going to be the same, but it's recommended that you would have one for each. I'm guessing they're talking about for siblings or relatives, but.
And a question is the agent a designated family member?
It can be, and it often is, but it doesn't have to be, right? Maybe you were a single child, you're an only child, and you were never married, so you don't have a spouse, you don't have children, and your best friend is your neighbor, and you have been best friends for 30 years, and that person's, let's say, 20 years younger than you, right? You might say, well, if I can't make my own decisions, I want my neighbor to make those decisions. So it doesn't necessarily have to be a family member, although it's pretty common that it is. That's, the person's spouse or their parents or their adult siblings or adult children, but it doesn't have to be.
And this is a question we get a lot. If you already have a family trust, do you also need to get a special needs trust?
And my answer is going to be generally yes, right? Especially if you're trying to provide for the individual with a disability, right? You don't want Social Security or Medicaid to get wind of that trust and say, wait a second, this person has access to these resources. They shouldn't have their benefits. They should have to spend their resources, right? And so the point is that they don't have access to it, that there's a layer in between the individual and the resources, in this circumstance, a trustee of a special needs trust who can provide that layer of insulation, we'll call it, so that the person can still be entitled to their public benefits. There's very specific language that has to go into the special needs trust in order for them to receive those benefits.
And Nicholas, are there options for families who can't afford an attorney?
So there are a few options. One might to look into, I'm guessing they're talking about for trust. What one option might be a pooled trust that I mentioned. There are, and this might be a question for Diane or one of her colleagues afterwards, but there are, some startup costs to that. But I think generally that would be more cost effective in order to get into, the situation where they can have resources for their benefit, but not necessarily have to front the cost and expense of reaching out and connecting with an attorney and going through that entire process.
And are there options for support if about guardianship?
So there are. Each geographic region has legal aid organizations. So the one in Central Virginia is called the Central Virginia Legal Aid Society. The one in the Tidewater area is called the Legal Aid Society of Eastern Virginia. There's Blue Ridge Legal Services for our western part of the state colleagues. In Northern Virginia, I believe it's called Northern Virginia Legal Services. So those are all legal services organizations that you can reach out to. You could also reach out to me. I do them for folks who can't afford attorneys. So happy to be a resource. All right.
Um, there's several more questions, so I don't know, would you like to keep going here or
Um,
wait to the
Go ahead.
end?
You just pop them away.
Okay.
All right.
What happens to um, a child if the parents who are currently the guardians pass away?
Okay. So hopefully the court order named a standby or another co-guardian, in which case that person could take over. Um, and so a lot of times when people are anticipating that, right? Like, let's say the parent who's the guardian is 70, 80, not able to really, manage that anymore. I'm seeing more and more that they're going back to court and asking for a modification and saying, hey, court, I'm getting older, and I need you, court, to apply or to appoint this person as a co-guardian with me, whether that's another adult child that the person has, or a niece or a nephew, hopefully somebody of a generation, below the parent generation.
Thank you. Okay. If Social Security replaces SSI payments with SSDI payments, once they pass and this amount exceeds 2,000, how does that impact eligibility for benefits?
Yeah, so well, one of the benefits that I was mentioning is Social Security. So they're receiving that benefit. The person can theoretically still qualify for Medicaid. It's so there are It depends on the Medicaid that they're applying for, right? There's long-term care Medicaid, there are Medicaid waivers, so it would depend on that benefit. So maybe email me afterwards, and we can talk about that, and I can connect you with a resource. Likewise, you know, as long as at the end of the month those resources are spent to below 2,000, that person should be okay from a benefits perspective. But always good to connect with. And I have a few benefit specialists that I work with, so I'd be happy to connect you for very specific questions.
And can a person who's receiving the waiver and SSI ever own a home?
Hmm. I think it would depend on what the waiver is, right? If they're on like a community living waiver that provides them with housing, so that again is a very specific question. I'm wondering what
But
what
but a trust could own the home.
correct. That's
Right.
correct. Yes. All right, so we'll continue on. If other questions pop up, please, or if you have questions pop up in your head, please feel free to put them in the chat. I'll get through a few more slides and then we might have
Great.
10, 15 minutes for open questions. All
Perfect.
right, so where are we in the process? We've gotten everything filed with all that information that I listed on those two slides. We've gotten our case number from the court. We've set our hearing date. And now what do? We mail out that notice. It goes to all of those relatives. The guardian ad litem personally gives it to the individual, and then there's a hearing. Okay, and the court at the hearing is supposed to determine, on the basis of clear and convincing evidence, whether the individual is in need of a guardian or conservator. And then the court appoints a quote suitable person to be the guardian or the conservator or both, giving due deference to the wishes of the individual. Okay. If a guardian or conservator is appointed, the court's supposed to inform him or her of their powers and duties, and to tell that person that to the extent possible, the respondent, the individual, is supposed to be encouraged to participate in decisions and to act on their own behalf and develop or maintain the capacity that they have to manage their own personal affairs. Okay, so the court makes that decision or determination and appoints a guardian or conservator at the hearing. Okay, oftentimes the hearings are pretty quick, and that's because the court's reviewed all that information that we've provided. The court's reviewed the medical evaluation, and the guardian ad litem has visited with the person and put together a report for the court, and the court has reviewed that as well. In some jurisdictions, such as Virginia Beach, the court actually reviews the order in advance to make sure that it complies with the statutory requirements that are going to be in the next slide or the slide after that. Next slide, please. Okay. Speaking of court order of appointment, the specific language is on the next slide, but just a preface here, right? It's important for us to do our own estate planning, right? To have our own advance directive and our own power of attorney so that somebody doesn't have to go through this somewhat arduous process for us, right? So the code provides that a guardian need not be appointed for a person who has appointed an agent under an advance directive unless they make a determination that the person, the agent, is not acting in accordance with the wishes, or there's some sort of decision-making need outside the scope of the advance directive. And same thing for a conservator, right? If we've appointed an agent under a durable power of attorney, a conservator doesn't necessarily need to be appointed. Additionally, a conservator doesn't need to be appointed for a person whose only or major source of income is from Social Security, right? As many on this webinar probably know, those resources are managed via a representative payee system. And so you don't necessarily need to be conservator of your soon-to-be or recently turned adult child if their sole or major source of income is from Social Security. All right, going to the orders. So all orders have to include this very big, bold 14-point font statements. Next slide, please. And I'm going to highlight two of them. They're all important, okay? The first one's going to list out all the rights and duties that the person has, including retention of rights, right? Does the person retain the right to vote or drive, make a will? What rights are they retaining? Okay, but I really want to focus in on number two. And I already mentioned number three, right? We talked about that annual report. So number two, so the guardian is supposed to encourage the person to participate in decisions. They're supposed to consider that person's expressed desires and personal values, and they shall not restrict that person's ability to communicate, visit with, or interact with other persons with whom that person has an established relationship. Moving down to number four, this is going to be on my common misconceptions one because while there aren't a lot of guardianship terminations or revocations, they all are subject to petition for restoration, for modification, or termination. All right. Generally, we don't see them because oftentimes there isn't a change in circumstance where the person goes from needing a guardian to not needing a guardian. But in the instance where that happens, they're fairly easily modifiable or terminable as long as the evidence supports that. All right. Next slide, please. All right. So kind of went through each of the steps. A common question is, how long does this take? Um, I received a call from an individual with an 11-year-old, and I told them to call me back in 6 years, that they are on the ball, and I'm glad that somebody told them about this and got this on their radar, but they're just a little bit early. Usually, I tell parents to reach out to me between when their child turns 16 and a half to 17. That's a good time in order for me to send out the intake forms that I need to have completed, including one completed by that medical evaluator. We all know some medical evaluators will get them back in a day, and I've had one take 4 months. So if you allow some buffer time, it allows you to get everything and the attorney to get everything lined up and filed accordingly. Okay, as the parent, everything can be filed with the circuit court at 17 and a half. Okay, and that's why I say 16 and a half to 17 is a good time to reach out. You can get everything filled out, you can have follow-up questions, and everything can be drafted and ready to go when the individual turns 17 and a half. Okay, so all those documents on the left there, cover letters, petition, that medical evaluation, the guardian ad litem order, that gets submitted to the court in an initial filing. It usually takes the court a couple of days to a couple of weeks to process that, to get a case number, and for the judge to review and sign the guardian ad litem order. All right. Once we know who our guardian ad litem order is, we can look to scheduling and sending out that notice. Different jurisdictions do them at different times. For example, some courts use a motions docket. So, for example, Chesapeake does these at 9 a.m. on Wednesdays. So, if you know who your guardian ad litem is, you can reach out to that person and say, hey, what Wednesdays are you available at 9 a.m. for a hearing in Chesapeake Circuit Court for a hearing on this petition? Okay, likewise, Fairfax and Loudoun, they do them at 9 a.m. on Fridays. So if you know your GAL, you reach out and say, hey, what Fridays are you in court? Fairfax Circuit Court this upcoming week for a 9 a.m. uncontested guardianship. Okay, other places, like a lot around central Virginia, right? So I think Richmond, Chesterfield, Hanover, Henrico, they use a specific day, right? And date and time. So you might reach out to the judicial assistant and say, I see that my case number CL 26-1500 was assigned to Judge so and so. Could you please let me know some availability that the judge has for a hearing on this petition? And they might give you 4 or 5 dates and times, and then those get coordinated with the guardian ad litem and with the client. We set that date and send out the notice. The notice is supposed to go out at least 10 days before the hearing, right? This is so that those people, those relatives, and the primary healthcare providers can receive a copy of the actual notice. All right. The guardian ad litem then goes and personally serves the individual when they meet and puts together a report for the court. And then we have the hearing. It's supposed to occur within 120 days of the filing of the petition. It's generally closer to 4 to 8 weeks. And that's where, again, if you got your forms to the attorney around 17 or 17 in a couple months, that gives plenty of time to have everything drafted, filed at 17 and a half, and gives a nice buffer window to complete the process, right? We don't have to rush to try to get it done in 3 weeks, which, can happen, but that can put a strain on the guardian ad litems, and they're already overworked. So it's important to try to be as flexible and give them as much time as we can. At that final hearing, we're going to provide a couple certificates to the court, and then the court's going to sign a final order. Okay, the final order, again, in my hypothetical, will say, Jane Doe is appointed guardian and conservator of John Doe. She has all these rights and responsibilities, and another number of other provisions that will go into the order. And then next slide, please. After the court signs the order, the person has to, this is critically important, go to the clerk's office and qualify as the guardian or conservator. One of the things that the court's going to do is they're going to set a bond. Okay, and the person has to go. Typically, it's just your word that you're going to act in that person's best interest. It's not secured. You don't have to pay money for the bond, but you sign a piece of paper that says, I'm going to act in this person's best interest. And so we usually submit those first two forms to the clerk who's doing the qualification, the incapacitated adult information form and a state police form. And then you get a little certificate. You get a copy of the order and you get a certificate of guardian or certificate of guardian and conservator. This next bullet is new as of this year, but you have to do a guardianship training. This is supposed to be completed within 120 days of qualification. It was put together by the Department of Aging and Rehabilitative Services. It takes about 30 minutes to complete. And then you also have to submit your annual Guardian report. The first one is due within 6 months of qualification, and then every year thereafter. And this goes to the Department of Social Services where the individual lives. And the last one, fortunately, I've only ever had come up once in my career, but it's a notice of restriction. Remember, I mentioned you're not supposed to restrict their ability to communicate with, visit with, or interact with other people. There's a little clause at the end of that that basically says, unless it's needed for their well-being, right? And I had to issue one for a non-family member who had been financially exploiting the incapacitated individual. You issue them one, they're not to see or talk to them or visit with them, and it gets filed with the court. Theoretically, they could contest it, but this person didn't because it was obvious that it was coming, and that was that. But normally, that's not one that we have to utilize. Next slide, please. All right, common misconceptions, and then we'll have about 10 minutes for questions. So one that I always get is, I don't want to take away all of their rights. And my question back is usually, well, what rights are we taking away that this person is exercising? And I'm not trying to be smart when I ask that. I'm just trying to understand, well, what are we taking away that you think is valuable to them, right? And I might say, well, their right to make decisions. Again, the guardianship orders incorporate big, bold letters. They're to be encouraged to make decisions to the extent they can, right? So if they can make A, B, and C decisions, then you're to allow them to make A, B, and C decisions, right? The right to vote is a big one that comes into play here. Typically, if the individual can tell you, who's the president, who were the candidates last election, it's not difficult to retain the right to vote. And I believe, and you probably could see this if you're on the ARC of Northern Virginia's newsletter, there's legislation to help retain those rights. The right to drive, right? If the person already has a driver's license and, is able to drive, well, they'll be able to keep that right generally. Or if the evaluator, the medical evaluator thinks that, hey, with some training and some guidance, they could drive, generally I've been successful in retaining the right to drive because, again, the goal here is to maximize the independence of the individual while also providing the protections that that person needs. I was told by my child's case manager, one of the other rights, the right to get married and the right to own or possess a firearm are implicated. I've never seen the right to retain or own or possess a firearm retained, but generally people don't have a problem with that one. And then the other one, the right to get married, again, generally that's without the consent of the guardian and the court, right? The way our public benefit system works is oftentimes it's ill-advisable for an individual with public benefits to get married. And so, they want you and the guardian to think long and hard about doing that and what that could cost. All right. I was told by my child's case manager to start the process at 15. That's a little early. As I mentioned, 16 and a half to 17 is a great time to reach out. But hey, if your kid's already 19 or 20 and you need to go through the process, like it's never too late to go through the process. Guardianship will fix all of my child's behavior and mental health needs. And this one is so hard, right? The person's like, well, I got guardianship, like everything should be okay. Unfortunately, it does not fix mental health. Now, it gives the ability of the guardian to make decisions for that person, but it's not necessarily going to change their behavior. All right, my child's school and care providers will continue communicating with me even after he turns 18. Sometimes, although not always. And you don't want to get left out to dry, right? You might say, well, my kid's got an IEP meeting and I didn't get invited. Or the doctor asked you to step out because your son or daughter has turned 18. All right, the state, well, this is another one. I actually heard this morning. The state will come and take away my child if I don't have guardianship of him at 18. That's not true. They're not out there looking to come and take away your child and have guardianship of them. In fact, quite the opposite. They want you to be your child's guardian, generally, right? We have public guardianship programs, but they have long wait lists because there are a lot of people that don't have a family member or a loved one who's willing to serve in that role. I'm already my adult child's guardian just by virtue of being his parent. No, the law presumes that when an individual turns 18, he or she is his own guardian, just like you or I were our own guardians when we turned 18. Aren't they impossible to terminate? No, they're not impossible to terminate. If, there are changes and the individual now has the ability to make appropriate decisions for them, they can be terminated. I terminated 4 or 5 last year. So it happens. It's just not common. I can already make medical and financial decisions for my child, even though he is an adult. No, again, an individual makes all of their own decisions unless they've appointed an agent or they have a guardian or conservator. And then lastly, I was quoted $7,500 by an attorney for the whole process. And while that may be a reasonable fee for a very contested guardianship, that does seem high in my opinion. Next slide, please. All right, and that's the same as the first slide, so you can have my contact information at the bottom there, my email, phone number. Feel free to reach out. And I think we have 10 minutes for any questions.
Excellent, because we have lots of questions. Okay.
Oh, good, good.
Okay. When providing the court with information on family and support people, can
Yep.
you designate people who should never be involved in the trust or the person's care?
Okay, so they mentioned court and they mentioned trust, and I want to separate those out because those are typically in two different processes. So the trust is something that the person is setting up, no court involvement generally, right? I might set up a trust for the benefit of my special needs child. I and my attorney could be the only person that know about that at that time because I'm both the settlor, the person setting it up, and the trustee, the person who's responsible for managing the trust, right? When I die, I might have a successor name. I should have a successor named in there. And at that time, that person will have access to all of the information that they need. But generally, there's no court involvement with a special needs trust, and nobody has to know about it except for the settlor, and typically, you should advise who your successor is going to be. Hey, just so this is on your radar. They mention court. That makes me think guardianship. And so, in guardianship, those relatives that I mentioned are entitled to notice, right? So I mention them because sometimes you might have single parent who says, well, other parent hasn't been involved in 5 years. Yeah, they haven't been involved, and that probably speaks to their inability or inappropriateness to be a guardian, period. But they're still entitled to notice, and to the extent that you can get their mailing address, we need to go and get it. Because the guardian ad litem in her process, she's going to go and look for all people related to this individual. And if we're hiding the fact that we know where other parent lives and their mailing address, that's going to look poorly. And frankly, the judge is not going to be happy with that. And it's going to delay the process, right? I actually had this happen. It was that we were all set for a hearing, and 2 days before the hearing, the guardian ad litem found the non-participant parent, got him a copy of the notice, and he showed up at the hearing. And the judge was like, well, why didn't you have notice in time? And then, well, why didn't you include his mailing address? So, and it delayed it 4 or 5 months. So it's important to provide all that, but they are entitled to notice. Now, if they're outside of that scope of relatives, like they're a cousin or a niece or a nephew or some far off relative, they aren't entitled to notice, and you just don't include their name in the petition and they don't get a copy of the notice.
Can you explain the difference between revocable and non-revocable trust?
Yes, yep. So these are done for tax reasons, but revocable means you can go in and make changes to it. You can make almost wholesale changes to it. Irrevocable, same for save for some very specific provisions that can be changed to address, updates in the trust code or updates in, the taxation of trust. They can't be changed.
And how we have a guardian in here in the put a question in the Q&A. They've never been asked to do an annual report. How are guardians notified that they're supposed to do an annual report?
Well, when were they appointed? Can they put the year? Because it's supposed to be in the order. That third bullet in the bold says the guardian has the duty to provide an annual report to the local Department of Social Services. That's been in there for like 15 years. So they were appointed in the last 15 years. They are court ordered to do that. The other is the guardianship code provides that. How are they supposed to be notified? Generally, the local Department of Social Services is supposed to send a letter reminder. They're supposed to receive a list from the circuit court, and they're supposed to send letter reminders. Now, clearly, not all of them do. But what I would say would be, get a copy of your order, see if it has that language in there. Even if it does, fill out a report for each year that you've missed and get it submitted to the Department of Social Services where your ward lives. Because what can happen if you don't, actually had this happen, the person, same situation, 10 years had gone by and they didn't know they needed to file annual reports, and the judge issued them a show cause. The judge basically said, you haven't filed your annual report as required by law for 10 years. Now come into court on this date and this time and tell me why. Now, within the 4 weeks since they got the subpoena and the hearing, they filed their 10 years worth of reports, and the judge fined them $500 and told them not to do it again.
Thank you. If the special needs trust is funded with a gift of stocks, who pays the taxes when the trustee sells a stock to pay for the beneficiary's expense?
Certainly. So, this is where you can get into some planning. If you're the parent and you're planning to leave stocks to the special needs trust, and they have appreciated over your lifetime, you are a special person who bought Amazon or Netflix in the early 90s. What you want to do is hold on to that stock until you pass away, because they'll get a step up in basis, right? So if the value of Amazon today is $1,000 a share and you bought it at $1 a share, if you sold it today, you would have to pay long-term capital gains on that difference, right? $999 in my hypothetical. If you died with the stock tomorrow, the person or the entity that received it would take it at a basis of $1,000. So if they sold it, they would have no gain because they had bought it, or they had a basis of 1,000 and sold it for 1,000. But ultimately, if you didn't do that, or maybe the trust has been holding the stock for a long time and needs to sell it because it needs some liquidity, then the trust would pay the long-term capital gains.
And this is a question we get often. If you have guardianship in Virginia but move out of state, do you have to get guardianship in the new state?
Yes, and technically you're supposed to get permission from the court before you do that. The 64.2 2019 says that you have the authority to move them within the Commonwealth of Virginia, but you must get court permission before moving them outside of the Commonwealth of Virginia. Now, does it happen that you get the permission before you leave? Not always, right? Maybe you get some military orders and it's pretty quick and you got to go. It's a can be a ask for forgiveness type deal. Just say, hey, court, I got stationed in Pensacola, Florida. Please transfer this guardianship to Florida, and you can get it transferred to the other state where you go.
If there are co-guardians and the individual becomes ill, do both guardians need to make medical decisions?
Hopefully your order was drafted so that either of you can act independently. Typically, that's how I draft mine, right? If maybe mom can take him to some things and dad can take him to some things, you give them the authority to act independently, and then you don't run into that issue. But it would
Let's
depend on what your order said.
let's just do a couple more. What time is it? We have just a few more minutes.
I can hang out for a
Okay,
little
if you can hang
bit.
on, I'm happy to hang on. When let's see, we did that one. What is the best way for a DD waiver recipient to inherit a condo that is owned by their parent?
Special needs trust.
Right.
That was a softball. But I'll add another layer, having it be done via a transfer on death deed. That's another tool in our estate planning toolkit that basically can automatically just pass the interest to the special needs trust and avoid the need for any probate. So that's another tool in our toolkit.
Oh, this is a good question just to clarify guardianship and conservator.
Yep.
If the child with special needs has a guardian, do they
Yep.
also need a conservator if there's a trust in place?
So it depends on what kind of trust it is, right? So if the individual, let's say, received a not life insurance, they received a an accident settlement, right? And they're going to receive $100,000. The person should become appointed their conservator with the authority to establish and fund a special needs trust. Now, if what they're talking about is, the parents want to leave that person resources, that's different. Typically, they would only need to be the person's guardian, and they can make decisions for their person that way and manage their finances. Again, this gets back to that little bullet about a conservator need not be appointed for somebody whose sole or major source of income is from Social Security. You can manage that via representative payee. But if the individual does have, $100,000, the incapacitated individual has $100,000 in resources, they're going to need to be their conservator to manage it.
If you have guardianship, are moving internationally for a few years and then coming back, uh,
That's a
is there
good
any
question.
is there any steps you have to take?
You know, if it's temporary and it's known that it's going to be temporary and you have no intent to remain in, I'm gonna make up a country, Germany, and you're planning to come back, you just don't know how long it's going to be. Maybe you're in the military. I might say don't do anything. Just kind of let sleeping dogs lie. Now, I don't. I'm only licensed in the Commonwealth of Virginia. I don't know what Germany's going to say, right? You might go to a German doctor, and the doctor's like, "Oh, no, no good. I need you to do this here before I talk to you." So I don't know what the other country will say as far as your decision making there. But as far as being here, again, if there's no intent to remain away for a significant period of time, and I think you're okay.
There's one more. Some of these you have answered before,
Okay.
um, in some fashion. Let's see. There's someone she oversees her sister's special needs trust.
Okay.
She's not
Interesting.
sure if there's it for a long time. The grandfather's will is tied to this, but
Okay.
she's not sure if there was a bank account tied to the trust. How would she find this out?
That's challenging because you have to know the bank. This can be hard for conservators too, right? Like, let's say you become conservator of your parent who has dementia, and you have no idea where they bank. You're going to be searching. But if you have an idea about the bank or banks where there may have been an account, typically what you can do is provide a copy of your certificate of trust, and that'll say, you are the trustee, you have the authority to manage funds in the trust. Here's a little bit of information about the trust, and then the bank can then tell you, well, sorry, we don't have anything in the name of that trust, or well, actually, here are those accounts that are in the name of the trust. So it's helpful if you know where or have an idea of what bank or banks you might be thinking of.
At what age can you start a trust?
You be the settlor when you turn 18. You can be the settle the trust. And they might have been asking at what age can they set one up for their
Or there?
child at any point. At any point. Um,
And then this is the last question. Should our home be retitled to ensure it passes to a special needs trust to avoid probate?
yeah, so I was mentioning that a couple questions ago, but with a transfer on death deed. So sometimes maybe you have a parent who owns the home by themselves. You could have a transfer on death deed that says, I, so and so, sole owner of this property, leave it to the blankety blank special needs trust at my death, with some other provisions that the code requires be in there. But that will, in essence, have that home not pass through probate. And the law calls it basically your interest extinguishes, and the trust would then own the property, right? It's kind of like if a husband and wife owned their home as tenants by the entirety, meaning they're married and they own it with a right of survivorship. If husband passes away first, wife now just owns the home outright. If wife passes away first, husband now just owns the home outright. Similar concept.
Maybe we need to do a future webinar on houses in a trust. Um, the rest, I think that's it for today. There are a couple of other questions that you did answer already. They were kind of duplicated. For some of those, I'll send out kind of a summary of some of these so that everybody has the information. We did talk a little bit about ABLE accounts. I will also include in the follow-up email, we have a really nice kind of comparison chart between the differences of an ABLE account and a special needs trust that really lays it out clearly and how a ABLE account can be used in addition to a special needs trust. And I'll also send out some information about our pooled special needs trust program. If you have any questions, Nicholas went ahead and put his contact information there, so feel free to reach out to him directly. And as always, feel free to reach out to me. So thank you so much for being here. Thank you for presenting. I really appreciate your time.
You're welcome. Thank you for having me.